Welcome to today's video. I'm Richard Chapo. I'm an attorney down in San Diego, California, and I've been advising online businesses for about 20 years now. Today we're taking a look at the importance of website terms and conditions. And before your eyes roll back in your head and you start snoring, it's important to understand that while this is not the sexiest of subjects, it is very important. If you're an Apple user, if you use Apple products and services, you've probably noticed it seems like every few days they force you to agree to their terms and conditions and changes in those terms. There's a reason they're doing that. The terms and conditions on a website act as a contract with your users, your visitors. And if you think about Apple, well, you probably never actually read the terms and conditions that you're agreeing to. And Apple gets to, set that playing field, if you will, on the contract because they get to draft all the terms. Well, the benefit is with your website, you get to draft the terms and conditions and, the things that you're going to put in there, the policies, what have you. People often contact me and say, hey, can you do something so that I can be guaranteed I won't be sued online? And the answer is no. Any moron can walk down to a local courthouse as long as they have a $200 fee. They can file a lawsuit against you. Now, whether they win that lawsuit or not, is a whole different issue, but you're going to have to deal with it, and it's going to be a pain in the butt. So the idea with terms and conditions is to draft them in such a manner that's going to create a playing field that will greatly mitigate your risk of being sued. It won't get rid of it completely, but you can go a long way to getting rid of a lot of lawsuits, particularly ones that are nonsense. So let's take a look at some of the issues that come up with terms and conditions. Let's start with practical issues. So your terms and conditions need to contain, your policies on just practical topics. Let's say that you have a site and you've created cameras, your own products, your own manufactured products. You're selling them. Well, you're going to need a clause discussing refunds. When are refunds going to be granted? When are they not going to be granted? What about defects of a particular type, or what if the person has used the camera for more than 10 days? Does that have an effect? Whatever those issues may be, you're going to need a clause in there. You're going to need a clause on exchanges. The person received the camera is damaged, they send you a photo, the camera is clearly damaged, the box is damaged, you can see it was a problem, they have to ship it back in. Well, who's going to pay for that shipment? All these little things that you just need to address. There are laws on some of the topics, but mostly it's just a matter of making sure that you set those those policies out, because we're going to have the customer agree to them later on at some point, and then they'll be bound by them, so you don't get any strange and bizarre requests from them. Then you're also going to need to include issues specific to the particular website that you're running. So, for instance, if you have a forum, well, you're going to need to include a list of rules and regulations for that forum based on the potential negative conduct of people. I think we all know there are just some jerks online, and so you want a set of rules that says if you post racist crap, we're going to terminate you. No posting of adult content on this this blog. No posting of whatever it may be. And you want a list of those items there. There's tends to be a standard list, but you may need to add something to it specific to your subject matter. And the goal being that you want to make sure that you can get scumbags off of your site. So now we get to the legal issues. So this is where things get a bit more important. The legal issues are really where you can tilt the playing field with your consumers in your favor if a legal dispute arises. A lot of this is the boilerplate language. Your attorney probably might not even ask you about a lot of this. They're just going to put it in because it's something that helps you, and you may not understand it or you may not care about it. It's just too boring. But let's at least cover some subjects so you'll know why this is important. Choice of forum clause. The choice of forum clause is simply a section in your terms that says if a legal dispute arises between one of the users of the website and yourself, the website owner, the website itself, that dispute needs to be heard in this particular location, and you're going to designate that location to be your county and your state. So why is that important? Well, think it through. Let's say you sell a camera for $500 to somebody in Maine. They get the camera, they don't like the camera. The two of you, go back and forth by email, and it gets ugly and mean, and they want to file a lawsuit against you in Maine, and they do. Well, you're in California, and going to Maine is going to be a pain in the butt. You're going to end up spending more money than you're probably going to have to pay out to resolve the matter. And so we look at your terms and conditions, and there's a choice of forum clause that says if a legal dispute arises between you, the consumer, and us, the camera website. Those disputes must be resolved in San Diego County, California. Okay. Now you're going to retain an attorney in Maine for a nominal amount of money. That attorney is going to do a motion to dismiss the lawsuit, and they're going to submit the terms and conditions showing that the customer agreed to them. And at that point, in maybe 80-85% of cases, the court is going to dismiss the main lawsuit. And they're going to tell the consumer, this is dismissed without prejudice. And that means they can refile, but they have to refile in San Diego, California. Now, do you think that person with their $500 claim is going to spend the time traveling to California, booking a hotel, doing all those different things to try to recover their $500? Probably not. It doesn't make financial sense. Why would you spend $3,000 or $4,000 to try to recover $500? So the practical effect of the choice of forum clause is, a lot of times, it will put an end to lawsuits before they start. And if you think that this is something that is somewhat tricky or doesn't sound like it's going to work, Google uses this all the time. A company as big as Google is able to get their choice of forum clause enforced, and you see lawsuits. There was a big one in New York. It was going to be a class action, and it was actually terminated, and they were forced to come to California and refile. So it can be very valuable. The other section we want to focus on now, just to kind of highlight some of the power of the boilerplate clauses, is an arbitration and class action waiver clause. So prior to 2011, businesses could not force consumers to give up their right to file a lawsuit in court and instead go to arbitration. State laws, there were states all over the place that had this law, and so it was on the books, and the Supreme Court had upheld it. However, by 2011, we saw the makeup of justices on the Supreme Court switch from liberal to conservative, and AT&T put a clause that was a class action waiver and an mandatory arbitration clause into its terms when it sold smartphones and mobile services. And Concepcion was a group, so it was AT&T Mobility versus Concepcion. They were a couple that had purchased the policy, and they were unhappy with it. They wanted to sue. And AT&T said, you have to go file arbitration, and you have to file individual lawsuits instead of class action lawsuits. And the Supreme Court ruled that was correct, that the Federal Arbitration Act that had existed since the early 1900s was now going to be viewed as binding on this issue and trumping all of the state laws. So all the state laws that said that you could not force consumers to go to arbitration, those were all void. So it was a major change in the law, and this is why people get fired up about the nature of Supreme Court justices. When they're being presented to the court and put up as a potential justice, there can be big ramifications. Everybody likes to talk about the hot button topics like abortion and what have you, but really the big effect is usually more on these contractual issues. So as of 2011, you can force your consumers to waive the right to trial and to go to arbitration instead. Why is that important? Arbitration is resolved in front of a retired judge or an experienced attorney in your niche. There is no jury, and the judges and the experienced attorneys, they tend to be more technical versus emotional in evaluating cases, and so businesses tend to do much better. Something like 70% of arbitrations end up being decided in favor of businesses. And even if it's decided in favor of the consumers, the awards are usually much lower because, again, the emotion's taken out of the situation. So it's very good for businesses, very bad for consumers. You also can force, now in your terms and conditions, to force consumers to waive their right to a class action lawsuit. So what does that mean? Well, class action lawsuit is a collection of plaintiffs, people who are going to sue, who are all suing for the same thing. And instead of having 10,000 different lawsuits, individual lawsuits, they all group together in one. And the value of that is because there's so much more value there, and the expense is reduced because it's one lawsuit instead of thousands. Big law firms will get involved and will put the money necessary into prosecuting those cases. And you'll probably see securities, class action lawsuits all the time. If you're up, after 11 o'clock at night, you'll often see, ads from law firms. Did you take this drug? You could have a right to, be compensated. Well, that's what they're advertising. So this is particularly important in the internet arena because, again, we go back to our purchases. Think about the things that you buy on the web. They're usually not big ticket items. So usually you're spending I don't know, $50, $100, something like that. I mean, I'm a slave to Amazon, and I don't think any of my purchases usually run more than maybe a couple $100. Not make a lot of them, but I just don't have big dollar purchases. Even if you're buying software or anything else, you're still usually at, well under $1,000. Okay, well, if you have a class action waiver and you can force people not to join others, in a lot of situations, they'll just abandon their claims. So let's give you an example of how this works. Zappos, a big online retailer, sells shoes, clothing, the whole deal. Amazon purchased them for a huge amount of money. In 2012, Zappos was hacked. And so their customer information was exposed, and law firms came in, and the customers grouped together to sue Zappos. And they sued them in a class action lawsuit. Zappos tried to get the class action lawsuit thrown out, and they said our terms and conditions state that you cannot have a class action lawsuit against us, that the consumers had waived it. Now, Zappos terms and conditions failed for a different reason, and we'll get into it in a bit. But the end result was that if Zappos had been able to enforce that class action waiver, the however many customers there were that were involved in the class action, let's say 10,000, those 10,000 would each have been forced to go file individual arbitration claims. And the amount of money involved would have been so low that they would have been they almost surely would have had to have represented themselves. Attorneys wouldn't have gotten involved. There just wasn't enough money there. So in that situation, out of those 10,000, how many do you think would have gone ahead and done it? 10%? Maybe 5%? The number would have been pretty low. A class action lawsuit is viewed as easy money by people, but if they actually have to get off the couch and go do their own arbitration and things of that sort, well, that's a whole different story. So Zappos would have saved a massive amount of money in legal fees, massive amount of money in potential damage claims, and so on and so forth. And so that's the value of these clauses. Are they boilerplate? Are they boring? Are they the reason a lot of people hate the law? Yes. Does that mean you shouldn't take advantage of them? No. You want these in your terms and conditions. Now, these are controversial types of clauses, so they have to be drafted correctly, and they have to be drafted with great detail and great effort. You can't use just forms and templates that are out there, because courts are going to be looking for a reason to invalidate these claims. So let's take a look at Zappos and see how that happened. So binding your visitors to your terms and conditions has become a huge issue in the last 10 years in internet law. To understand it, we need to first talk about wraps. So you go to a blog, let's say you go to your favorite blog, and you're reading an article and everything else, you get to the bottom and you notice down in the footer, there's a link that says terms and conditions. Let me ask you a simple question. In all the years you've used the internet, how many times have you gone down and clicked that link to read the terms and conditions? Once, maybe. The answer for most people is probably never. The type of approach to terms and conditions is called a browse wrap agreement. And in 1999, when the courts were first looking at the internet, browser wrap agreements were fine. Courts would rule that they would bind people who visited the site to the language in the browse wrap, which were essentially terms and conditions. And you have to remember at that point you had 60-year-old judges, looking at the internet, this brand new thing. They couldn't work their DVR, much less figure out the internet. And so, they just said, well, sure, that's enough notice. That's fine. Well, if you flash forward 20 years later to where we are now in 2018 and about to be 2019, courts are a bit different. Judges have grown up using the internet, and they understand full well that when people go to a website, they don't scroll down to the bottom, click the terms and conditions link, and then read the document. Nobody does that. And the judges know that. And so they will not enforce browse wrap agreements. They just won't. There may be the rare off case where that's happened, where maybe the user admits that they actually did read the terms and conditions or something like that. But for you to rely on that position from a legal perspective would be insane. Nobody, just assume for the purpose of this that nobody reads those, and the court is never going to enforce them. So instead, what you need is a click wrap agreement. And what a click wrap agreement is, I'm sure you've gone to sites and you've made purchases and maybe signed up for a membership or something, and there's a box and they want you to check the box. And next to the box is a statement that says, yes, I agree to the terms and conditions and privacy policy of this website. Well, that's a click wrap agreement. You're clicking affirmatively that you agree to the terms and agree to be bound by them. It's like the signature on a contract. And in taking that action, you are binding yourself, to whatever that language is that's in those terms. Apple makes you do it, and so on and so forth. So you want that on your site. It may sound like a technical pain in the rear to do, but it's not. There are free scripts floating around everywhere online. So if you're designing your own site, you can go find one of them. If not, tase your webmaster and make him go get one. They're easy to incorporate. You want to create a record of the transactions. You cannot pre-check the box. The box has to be blank because, again, we need the affirmative, the affirmative act by the consumer. But once they check that, then they are bound by your terms and conditions. And so those choice of forum clauses, arbitration clauses, class action waivers, your refund policies, all that stuff becomes binding on them, which is very important because, again, all that's typically going to be written in your favor. So what happened to Zappos? Well, so Zappos had the class action waiver forms and all of that, but the problem was they were using a browser app agreement, not a click wrap. So they didn't require, consumers to essentially sign the contract. And if you think it through, it's pretty stupid. Somebody at Zappos really blew it because there were plenty of opportunities to do that. When people go to Zappos, they're there to purchase clothing or shoes. And so that box should have been included. The checkbox should have been included as part of the checkout transaction. I mean, it wasn't hard to do. So I'm sure that there was some rather aggressive meetings at Zappos over that very issue, because the failure to use that certainly resulted in a lot of expense. Let's just put it that way. So what about templates and forms? You're just starting out, can I go out and, get a template or, find a form online or borrow terms from another website? And the answer is very much that you pay what you get for. I'll be honest with you, if it was 2002, you'd probably be okay doing that because the law was so much, such its infancy, if you will, at that point, that a general set of terms and conditions could probably get by, provide you with some protection at least. But in these days, the law is caught up. You need custom terms and conditions. And before you think I'm trying to sell you, I'm in California and I only take clients in California or from outside the United States. So that leaves all the rest of the states where, I wouldn't take clients from. You would need to go talk to a separate attorney. So I'm not saying that just to try to, generate fees. Although, of course, I'm happy to take your money. But the template forms that you see, they're often horrible. They're often terrible. I'll give you an example. It's not with terms and conditions, but with privacy policy. You'll see these templates and the forms will maintain a statement that says, we will not share, sell, or rent your personal information to any third parties. And all I can say to that is, really? Well, then you're an idiot, because think it through. When you go to sell your website, how are you going to sell it? The people who are purchasing your website are going to want your mailing list. They're going to want your customer list. That's a huge part of the value of an online platform. If you're buying a dating site or you're buying, a social media site or something like that, what value does it have if you don't get any of the personal information? What value does a dating website have if you don't have any people on the site? None. Zip. Zero. It is one of the stupidest things I've ever seen anybody write. And so it's, and did that term cost, did that template, cost you much up front? No, maybe it was free. Maybe it was, $20 or whatever, but it's sure going to cost you a lot on the end. And if you think I'm being, frivolous about this, the dating site True.com ran into this problem. True.com was a fairly successful dating site, but their parent company had all kinds of problems and ended up into bankruptcy. And so when the parent company went to bankruptcy, all the assets, including True.com, get dragged into the bankruptcy. And another dating site called Plenty of Fish tried to come in and purchase the member database of True.com. And they offered, I think it was $700,000. And attorneys generals in a number of states objected. And they said, no, this can't happen, because True.com, in their privacy policy, it said they would not sell, share, or rent the personal information of their members to third parties. Well, Plenty of Fish was trying to buy that information, and thus True.com was trying to sell it. And the court ruled in favor of the attorney generals, and they terminated the sale. and $700,000 in value of that website went poof. Big problem. So when you're using templates and forms, you run the risk of, this kind of a thing. You also need to read the templates and forms because they often may have something in there that is in conflict with your actual practices. So you want to be careful with that. And one final additional thing, borrowing terms and conditions. What are we talking about here? You've copied your terms and conditions from another site. Really, really bad idea. Incredibly bad idea. I've seen some of my terms and conditions that I've drafted, copied, and I've contacted people, not so much in anger, but just to say, you really think this is a smart move? Because let's talk about it. We've just been talking about it. Terms and conditions need to be customized. Well, there's a good chance that those terms and conditions for that other site were customized to that site, and they may be, even if that site is a competitor in your field. Well, they're still going to have different issues with their websites. Let's talk about the choice of forum clause. Maybe your competitor's in Florida and you're in Los Angeles. Okay. And if you copy their terms and conditions and just publish on your site and a dispute arises between you and one of your customers, well, I'm pretty sure the choice of forum clause is going to say the two of you have to go to Florida to resolve it. So not only are you going to be embarrassed in that you have to fly from LA to Florida for some reason, but I can guarantee you the judge, the arbitrator, or whoever it is that oversees that case is going to think you are a blithering idiot. And they're probably going to decide against you if for no other reason than just to spite you for being a moron. So you really don't want to go down that path. I'm sorry, I don't mean to be harsh, but we see this all the time. Not just me, other attorneys, my peers, we all see this. There was a well-known dispute between two parties, one in San Francisco, one in LA, and the site in question had copied terms and conditions that said the choice of forum in New York. And so you literally ended up with two parties that hated each other in a New York courtroom. And the judge kept asking every couple of days, "Why are you here?" How did this happen? And it was just a disaster and a complete mess. So templates and forms, you get what you pay for. Most attorneys, particularly if you're starting out, they're going to charge, probably a healthy fee for terms and conditions. I don't know what my peers charge, but it could be anywhere from, maybe $800 up to a couple grand, depending on what you're doing. But they will offer you payment plans. We do recognize that you're starting out. The last thing you want to do is, pay a big lump sum fee. So, I offer payment plans over many months, and I'm pretty sure most of my peers do as well. So getting it right would be important. Okay, that's it for today's subject, the importance of website terms and conditions. The takeaway from this, hopefully, that you'll get is that, yes, they are important, but they're important because they help you. They can help prevent you from getting sued online. This is really a place that you want to focus on. You want to spend a little money because it really can be advantageous to you and what you're trying to do online and keep you safe. So if you have any questions or comments, you can always reach me at SoCalInternetLawyer.com or leave a comment below. If you're going to ask a question about a specific legal situation, don't leave a comment below. Just contact me through the website. You want to maintain confidentiality and you don't want those comments out there. So that's it for today's video. I hope you enjoyed it, and feel free to subscribe to our channel. We'll be publishing videos on internet law and the online business world at least a couple times a week. And so hopefully we'll see you on the next video. Thanks.